Hi everyone, welcome back to our channel. For today's video, we'll be discussing a topic we get asked about every time a dispute about an estate comes up. What is estate litigation like, and how much does it cost? As we go through this topic, keep in mind that this information is specific to estate litigation. Different types of trials have different processes, and the costs can be significantly different depending on the situation. Also, this discussion is based on the parties having legal representation. The fees we talk about here are not necessarily applicable to self-represented litigants. Before we start, let's cover some basic information. Some estate litigation goes through every step of the process, but most don't. The majority of estate litigation is settled before the matter gets all the way to a trial. Since no two estates are exactly the same, even ones with very similar issues, the cost for estate litigation varies. There can be a difference from one province to another, and even from one lawyer to another. The information about fees in this discussion are guidelines, not firm prices. In larger jurisdictions, like major cities, litigation tends to cost more and take longer. The wait is due to the high volume of people using the court system. The names of specific documents may also be a bit different from one province to the next, but the basic idea is the same across Canada. Remember, as we go through this topic, that the information provided is a general guide and should not be taken as legal advice. This is an overview of the estate litigation process and the general progress that a lawsuit takes. Litigation isn't linear. There can be a lot of back and forth at any particular step. This means that certain stages of the process can take longer than others. Let's take a look at each of the stages in more detail. To start estate litigation, someone files a statement of claim. This person, or group of people, is called the plaintiff. A statement of claim tells the court the plaintiff's position, what their argument is, and what sort of remedy is being sought. It also includes the evidence the plaintiff has to support their position. Sometimes this evidence is attached as exhibits, but that can also come at a later time. A statement of claim is a sworn document. So, as part of the document, the plaintiff signs an affidavit with a commissioner for oaths or a notary public if the plaintiff lives in a different province from where the litigation is taking place. Swearing the affidavit makes the statement of claim sworn evidence. This is important later during cross-examination. If the statement of claim itself isn't sworn, it can be accompanied by an affidavit that says the person has read the statement and swears it to be true. Additional affidavits with further information may be included later. Once the statement of claim is signed, it's filed at the court. The clerks will assign the matter a court file number, which will be used for all future documentation relating to the litigation. A copy is also served on the party or parties on the other side, called the defendant. If the plaintiff and their lawyer know that the defendant has legal counsel, the statement of claim is served on the lawyer. If the defendant doesn't have a lawyer, it's served on the defendant personally. The defendant then has 10 days to file a response, called a statement of defense. This document is filed at the court using the same court file number assigned by the clerk and is also served on the plaintiff. Once the court receives the statement of defense, a court date can be assigned. This doesn't happen automatically. One of the parties needs to contact the clerk to set a date. Since the plaintiff is the one who started the matter, it's usually the plaintiff who calls. The first court date is called a return date. This is a very short court appearance, and it usually only takes a few minutes. This court date is to set a time in the future for a longer period of time, during which the issues can be heard. The return date is the initial meeting that the lawyers attend to find a date that works for all of the lawyers and the court. The future date could be several months down the road, or longer in large jurisdictions. The major fees for Step 1 are for preparing the statement of claim. Since this is the beginning of the process, it involves all of the initial prep work, as well as reviewing all of the supporting evidence. It can take several hours to draft the document and send it back and forth between the client and the lawyer with edits. Common disbursements during this time include court filing fees and service fees. Some jurisdictions use process servers, who are individuals who will hand-deliver the document to a party who lives within a certain distance. The average cost for this step of the process is about $5,000, but it can be higher in larger areas. While the parties are waiting for a court date, the process can go one of two ways: negotiation or discoveries. Negotiation is an attempt to settle the matter without having to go through the entire court process, whereas discoveries are a formal exchange of information. We'll look at each option more closely. Alternatively, the parties could go through mediation, a process where the parties get together and try to reach a settlement. This process is led by a neutral mediator, and we'll look at this option in more detail in another video. The goal of negotiation is to settle some, if not all, of the issues brought up in the statements of claim and defense. Litigation can be a lot easier if some of the problems can be sorted out without using the court. Anything that can be resolved through negotiation doesn't need to be heard in open court. This saves time and, by extension, money. If all of the matters can be solved, the parties can sign a document called a consent order and submit it to the judge. This document says that the parties have agreed to a solution and they both want the matter to be removed from the court docket. If the judge agrees, the consent order is issued and the matter is taken off of the court schedule. Discoveries are the formal exchange of information. The parties share documents and the evidence used in their statements by answering specific questions posed by the other party. As we mentioned before, it's important for the statement of claim and statement of defense to have an affidavit because it makes the statement sworn evidence. In litigation, anything that is sworn evidence can be cross-examined. In discoveries, anything that is sworn can be questioned. Sometimes discoveries can lead to negotiation. It may turn out that there are matters that the parties can agree on. On the other hand, one party may inadvertently admit to something that can then be used by the other party to support their own position. Negotiation is less expensive than discoveries. With negotiation, the bulk of the fees come from sending information back and forth and preparing various settlement offers. If a settlement can be reached, there will also be fees for drafting, executing, and filing a consent order. The average fees for this process are about $1,000 to $5,000, depending on how long the negotiations take. Discoveries tend to be more costly than negotiations. A substantial amount of time goes into questioning the other party and reviewing the responses. Common disbursements during this time include shipping and mailing fees. On average, discoveries can cost $5,000 to $10,000. The next step in the process is the court hearing or trial. This step is reached either by failed negotiations, partially successful negotiations, or proceeding through discoveries. This is the hearing date that was set at the return date and is heard in open court. This means the hearing is open to the public. Ideally, enough time is scheduled to hear all the issues so the judge can make a decision. The judge will have received both the statement of claim and statement of defense before the hearing date, along with any additional affidavits, and should be familiar with the basics of the issues. However, if the judge determines that the matter needs to be heard in more detail, the matter will be set down for trial at a later date. Because estate litigation contains a lot of he said, she said accusations, it's not always possible for the judge to make a decision at the hearing date. The trial is the most expensive part of the litigation process. During the trial, the lawyers present their arguments. This is a verbal explanation of the issues and the client's position. Any matters that were settled during negotiations are not included because those matters are off the table for discussion. A trial binder is also prepared. This is a bundle of documents that each of the parties agrees to. For example, a copy of the will may be included, and both parties agree that the document labeled the will is the will that's being contested. Part of the trial includes calling witnesses, and this almost always includes the plaintiff and defendant. Additional witnesses can be called by either party to provide testimony. Anything said as testimony is sworn to be true under oath by the person giving the information. If the person lies, it's perjury, and this comes with hefty consequences. The witnesses who are called can be cross-examined by the lawyer for the other party. For example, if the plaintiff's lawyer calls a bank executive as a witness, the defendant's lawyer can also question the banker. On TV and in movies, this is usually where someone bursts into the courtroom with a surprise witness. Real trials aren't this exciting. Surprise witnesses aren't allowed. The purpose of a trial is to have a thorough examination of the issues and evidence, not to ambush the other party. Following each day in trial, there are post-court meetings between the lawyer and the client to debrief what was said and to prepare for the next day. Preparing the trial binder can be somewhat time-consuming, but the major fees in this step are for the lawyer's time spent in court. The longer the trial, the more expensive this step is. The most common disbursements during this step are travel expenses for witnesses. Some witnesses may need to be brought in from out of province. The least expensive court date is the hearing date. If the matters can be solved at this step, court fees could be less than $1,000, depending on how much time is set. For a trial that is 1 to 3 days, fees can range from $5,000 to $15,000, and a week-long trial can be up to $30,000. Trials that are scheduled for more than 1 week can easily be more than $30,000. Contesting a will without a lawyer, the DIY Guide for Canadians, is available at www.selfcounsel.com. Check out the link in the description box for this video. Where to find us. Visit our website at butlerwillsandestates.com, visit our blog, estatelawcanada.blogspot.ca, or email us directly at chelsea@butlerwillsandestates.com. If you like this video, make sure to click the like button, and if you want to see more videos like this, make sure to click the subscribe button.